Okay, so namaskar all of you. So today, uh, Shrima madam will be starting with your UGC NET class for jurisprudence. Ma'am has scored All India rank 35 in JRF law. Okay, in the last cycle, that is June 2025. So I request madam to take over.
I can use it like that. Okay. Thank you so much. Good evening. Thank you, everyone. So, my name is Shrima Bhattacharya, and sir has already introduced me. So, I will be teaching the jurisprudence. Shall we start?
It's already
Okay, okay. So, basically, we'll start with the class of jurisprudence. First of all,
just be careful because a lot of times like it can get entangled.
okay, okay. Yes, sir. Okay, sir. So basically, we will be starting with the jurisprudence class. Jurisprudence. Jurisprudence how to rub it? I don't know. Basically, jurisprudence. What is jurisprudence? Everyone knows that jurisprudence consists the basic essence of the law. It means when we study law, when we study the nature of the law, jurisprudence is the subject which deals with that portion of the law. Every authority has the power to make laws. But what is law? How we should constitute a mechanism where we can have a proper and well-structured law. Jurisprudence gives us that idea. Okay. So, during the whole syllabus, when we go through the syllabus, we see the basic foundation of jurisprudence. After that, we will be dealing with different structure of jurisprudence, different schools of jurisprudence. By schools, we mean there are so many thinkers from various centuries, from 18th, 19th, 20th century. There were so many philosophers, there were so many scholars who dealt with the nature of the law, who made us understand what is the actual essence of the law. So with this, we will be starting with the basic concepts of jurisprudence. The basic meaning of jurisprudence is, jurisprudence deals with what? Jurisprudence deals with the philosophy of basic of law. Philosophy of law. Okay. Philosophy, by what is the meaning of philosophy? Means the abstract sense of the law. What law ought to be. Okay. What should be the actual nature? What should be the essence of the law? Okay. So we will be dealing with it. Okay. Now we are talking about, we are constantly dealing with the term law. But what is law? Okay. Law, everyone knows that a human being is a social being. We need a society to live in. Okay. we live in a society, and to live peacefully, to live in a good condition, we need certain kinds of rules and regulation that can conduct the human behavior. Law are those guidelines, law are those rules and regulations which help us to conduct the human behavior in a particular society. So we cannot just define law in a specific arena. Law has a broad perspective. Different kinds of society needs different types of law. Okay, as a human being, we evolved with the time, and to regulate that evolving features of the human being, the law should also evolve itself according to the time. Okay, so if we talk about the nature and the functions of the law, then we can say that law denotes different kinds of rules and regulation to a particular or a different kind of society. Okay, in village there are different kinds of, in urban areas there are different kind of laws. Okay, in rural areas there are different kind of laws. Why? Because the mindset of urban areas are quite different from the mindset of rural areas. Okay, so different society needs different kind of laws to regulate themselves so that they can live peacefully, so that they can have a proper structure of administration. Law helps in that. Okay, okay, from the perspective of a society, from the perspective of the society, what the law should be, from the perspective of the lawmaker, the governing authority, what the law should be is quite different. Okay, so from the point of view of societal arena, the law is kind of justice. What is justice? Justice is the end, law is the means, right? Law delivers justice to the society. So for society, why the society need law? The society need law to have a justice. Okay, then morality. Morality is another concept of law. What is morality? Morality are certain moral guidelines which come within the human behavior. Okay, then we have reasoning. Okay, what is right and what is wrong. We have laws to maintain the order. Okay, to maintain the proper public administration. We are understanding it from the point of view of society. Now, from the point of view of legislature, what is legislature? Legislature is that authority who makes laws. Okay, then for those, the law should be, what is law? The law are the statutes which they make. What is the statutes? The law. Okay, the law are the guidelines, the law are the ordinance. What is ordinance? The laws which are made by the president. Okay, and the rules, regulation, the orders, it is from the point of view of the legislature. And from the point of view of this court, what is law? The law are the judgments. The law are the decree which the court grants. The law are the injunctions. Okay, so these are the different point of views which explains the nature of the law. So law consists all of these aspects. Okay, while understanding the law, while understanding the law, while understanding the law, we have to divide it into two aspects. The one is understanding of law. While understanding the law, we have to divide it into two senses. The first one is abstract sense, and the second one is concrete sense. Okay. Now we will be dealing with it one by one. What is abstract sense? Abstract means as a whole. Okay. It means that abstract sense refers to the concept of law. While understanding the actual essence, actual nature of law, we will be dealing with the abstract sense. And what is abstract sense? Abstract sense is the concept. In abstract sense, we understand the concept of law. Okay. What is the actual nature of the law? How law should be made? What are the ingredients? What are the elements that should be present in the law? Okay, in abstract sense, we understand the law as a whole. We are not dealing with a particular kind of law. No, in abstract sense, what the law should be. We deal with that. Okay, understanding the actual nature of the law, essence of the law as a whole. Okay. So in this, we deal with the actual nature, we deal with the actual essence of the law. It laid down, sir, how to rub it like, as a whole? Okay.
On. Lastly, you want to give it here.
Okay. So, as we are talking about the abstract sense laid the foundation of philosophical nature of the law. What law ought to be, okay, in theories, not in practical. Okay. The abstract sense deals with the phenomena, with the juridical phenomena, okay, of the society. Abstract sense and concrete sense. First of all, we understood what is the ingredient in the abstract sense. Abstract sense talks about the nature, the essence of law as a whole. Okay. Then we understood that in abstract sense, we study the juridical phenomena of law. Okay. Then, what is the nature of abstract sense? It is, in this abstract sense, we understood law as a whole, means it is universal in nature and theoretical in nature. It means that in abstract sense, we try to understand that what should be the law. Okay. In theories, the ideal condition of law, we deal in the abstract sense. Okay. Other than that, the jurist in abstract sense deals with the question of what is law. Okay. The jurist deals with the question of what should be the law? What is law? What are the ingredients that should be present in law? Okay. In abstract sense, we are not concerned with a particular law in a particular place. We study the law as a whole. Okay. As I said, in this sense, we try to understand the ideal conditions of the law. Okay. No matter whether those ideal conditions are fulfilled in a practical situation or not. We only study law as a whole, that these are the ingredients that should be present in a law. What the law should be in an ideal situation. Okay. While studying the abstract sense of law, jurisprudence comes into picture. Okay. As I said, jurisprudence, what is jurisprudence? Jurisprudence deals with the philosophy of law. As I said, the juridical philosophy of law we study in abstract sense. So, in this sense, we study the jurisprudence. As I said, the jurisprudence is a subject of the nature of law, the essence of law. Many thinkers, many philosophers give their philosophies, give their theories regarding the nature and the essence of law. With time, we have so many schools which talked about different natures of the law from the different perspectives of different society. Okay. So these are some of the elements of abstract sense. Like when we deals with the abstract sense, we understand law as a whole, what the law should be. Okay. Now coming to the concrete sense. Okay. What we deal in concrete sense? In concrete sense, we basically try to understand the actual, the practical application of the law. What a particular law in a particular society is. Okay. In concrete sense, we are not concerned about the ideal features of the law. We study the law as it is. Study of law as it is. As it is. Okay. Understand? We study the law of a particular area. We study a particular law. Okay, in concrete sense. For example, if I talk about section 300 of IPC, we talk about the definition of murder. Okay, what the particular law regarding murder talks about? What are the punishments? So, in concrete sense, we talk about the law of a particular area, of a particular field. We are concerned with the practical applicability of the law. Okay. In this sense, we study the statutes. Okay. We study the statutes. We study the orders, ordinance, which the legislature, with the law, which the lawmakers makes. What is the nature of those statutes, those ordinance? Okay. So we can conclude that in concrete sense, we understand law in a particular way. Okay, we are not understanding the law as a whole. We are emphasizing to a particular nature of the law. Okay. It is particular and practical in nature, whereas the abstract sense deals with the philosophical aspect of the law. After that, the concrete sense also talks about the nature of the law in a particular society. It says that the law is a social institute which are made to maintain the order and to maintain a particular system in a society. Okay, law is a social institute which is enforced by the state or any authority, okay, to govern the society. To govern the society. Understand? It is a social institute which are made by a particular authority. Let's say the state makes laws, and those laws are social institute which are made for the governance of the society. Okay. Abstract sense, there is another point which should be noted, that the abstract sense is a kind of inclined towards the natural law theory of jurisprudence. Why natural law theory? The natural law theory deals with the philosophy, what the law should be, and how the law is connected to the morality, the divine concept. Everything deals in the natural law theory. So if we see, the abstract sense is slightly inclined towards the natural law theory, whereas the concrete sense is slightly inclined towards the positive school of law, imperative school of law. We will be understanding these concepts, these schools eventually, but for a general idea, what is imperative school of jurisprudence? What is positive law? Positive law is a theory given by Austin, and in this theory, Austin says that a law is nothing but a command. A law is nothing but a command given by the sovereign authority, sanctioned, backed by the state. It means that law are those commands which are given by a superior authority, which are sanctioned by a superior authority, which are backed by a superior authority. In natural law theory talks about the sorry. Natural law theory says that the law is given by a divine force. It is not a man-made institute. It is given by a divine force. God has given us certain guidelines. God has given us certain instructions, which we as a human being, as a social institute, we follow them. Okay. In natural law theory, the thinkers, they connect the morality with the law. Okay. But in positive school, which is given by the Austin, it clearly mentioned that morality and law is completely different entities. Okay? They are completely a different aspect of the study. Okay. Okay. For the students of UGC NET, how you should deal with this subject? Like, first of all, you should be aware of the schools you should be aware of the thinkers of different schools. Okay, go through the definitions given by those thinkers. What are their perspective? What are the key elements of their theories? You have to remember those thinkers thinking, basically. Okay, you should go through the books written by those thinkers, all the what I can say, all the philosophies, important books, important concepts. Go through those, read it, and remember those thinkers. Okay, so till now we have kind of tried to understand the basic foundation of law. What the law? How to understand law? How to understand it? By these two sense, abstract sense, and the second one is concrete sense. Through these senses, we can understand the nature of the law. Okay. After that, if I talk about some definitions given by some thinkers, like some thinkers like Austin, as I said, father of positive law. What did he say? He said that law and morality is completely a different entity. They are completely different entity. Okay. Law has nothing to do with morality. Then what is law? As I said, according to Austin, according to positive school of jurisprudence, law are the commands sanctioned by the superior authority. We can say sovereign state. It means that there exists some kind of authority which make laws for the inferior one, for the society. What is the role of state? The state makes laws to regulate the society. That state sanctioned those commands, and those commands are laws. As per the imperative, we can also say imperative school of law. Okay. There is another thinker named Hegel. Okay. He said law is the expression of general will. Law is the expression of general will. What does it mean? It means that the society as a whole make some kinds of rules and regulation to themselves to regulate themselves. The general will of the society as a whole makes a particular rules and regulation. Okay. Salmond. There is another thinker named as Salmond. Okay. He said, law is the body of principles. Law is the body of principles recognized by the state to administer justice. He said, law is the body of principles recognized by the state to administer justice. It is a body of principles, those principles which are recognized. There are so many moral principles, there are so many legal principles. Salmon talks about the legal principles which are recognized by the state. Okay, the state has recognized those principles to administer justice, to deliver justice. Okay, so students, you have to go through such thinkers and those definitions given by these thinkers. Okay, this is the general idea. Now, if we talk about the meaning of law, as I said in the starting of the class, that we cannot just define law in a single line, in a single definition. Law is a very broad concept. Law includes every aspect of the society. As we have learned about the different point of views of society, of legislatures, of courts that we call judiciary, okay, they have different point of view regarding the law. So by this, we just cannot confine the definition of law in a single sentence or a single paragraph. Okay, law has a very broad meaning. Okay, the meaning, the nature, the essence of the law change with the society. As I said, different society has different kind of laws. The urban laws are different because the mindset of those people living in a particular society is different from a rural background. Okay, so different society have different kind of laws. Okay, and further, different meaning of law to different society. Okay, the second one is law is subjected to amendments. Law is subjected to amendments. It simply means that with the changing nature of this society, the law should also change. The law should be amended with time so that it should well, it should fit well in a particular condition of a society. ठीक है? For example, earlier there were no laws for dowry. There were sati pratha. If we talk about the Hindu society, if we talk about the Indian society, there were no law regarding dowries. There was a sati pratha. ठीक है? But with time, as the society evolved, certain kinds of laws were made to deal with certain conditions, to deal with such practices. Okay, the law should amend. Okay, different aspects of society have different kind of law. Like in Hindu, we have a law which prohibit bigamy. In Hindu law, bigamy is punishable, whereas in Muslim law, it's not. In Muslim law, 4 wives are allowed. Okay, so different society has their sense of law. They have their kind of understanding of law. Okay, if we talk about the general, what we can say, the general meaning of law, then what is law? Law are the legal orders. Law is the legal order, no? Those orders are made to conduct human behavior in a proper manner, conduct human behavior okay, and such orders are established to maintain the society, to maintain the society. So these are the general, we can say the general features of the law. If we say law, then law means all of these. Okay? Okay. We have sort of dealt with the basic foundation of law, how to understand law. There are 2 different ways. Abstract, in an abstract sense, we can understand the law. In a concrete sense, we can understand the law. Okay. Then we kind of learn about the different thinkers and their perspective regarding the law. After that, we learned about the meaning of law. So this is the basic foundation of the nature and the meaning of law. Now, let's talk about the nature of the law in a more elaborate form. Okay. Nature of the law. How the law evolved. How the law evolved. Let's talk about the evolution from the ancient time. Okay. If we talk about the ancient Hindu law, okay, if we talk about the ancient Hindu law, then in that Hindu law, in a particular Hindu law, there were no difference between law and morality. Okay. In a Hindu law, morality consists the basic foundation of the law. Morality was the basic foundation of the law in ancient society. Okay. With the time, with the changing nature of the law, that perspective of having a homogeneous nature of law and morality evolved, and it got changed. After 18th century, in the 19th century, if we talk about particular century, it's 19th century, positive school of law came into picture. As I said earlier, positive school of law said that no, law and morality is completely different. Morality does not institute the basic foundation of the law. Morality is completely a different entity from the law. It is from the point of view of positive law, which was given by Austin. Okay. So, we can divide the nature of law. We can divide the nature of law in majorly in two schools: natural school of law, and the second one is positive school of law. As I said, natural school of law, according to this law and morality is same. Okay. While the positive school of law says that no, law and morality are completely different. Laws are those commands given by the superior authority. Okay. There is no place for morality. After that, certain other schools came into picture, that we can say philosophical school of jurisprudence, sociological school of jurisprudence. Okay. These schools we will be dealing with further. So with the time, the nature of law also evolved. Okay. Different schools of thoughts, different schools of jurisprudence dealt with different nature of the law. Some says that law is nothing but a divine guidelines. Other school says that no, laws are the man-made commands. Some other says that no, law is made only by the society. Okay. Some says that Law is not a man-made institute. It has a historical background. Okay, history makes laws. So different schools of jurisprudence deals with different nature of the law. If we talk about the general function of law, then we can conclude from the understanding of the nature of law, we can conclude that the main functions of the law is, as I said, main function of law is to regulate human conduct. Okay, why we need laws? Why we need certain guidelines, regulation? So that everyone in a society can live peacefully. So that the society, the civilized society, should have certain kinds of boundary in which they can enjoy their rights, and also they should have certain kind of duties towards the other people. Okay, law provide law provides a mechanism to maintain a balance between rights and duties. Every individual of a society has certain rights, okay? But with those rights, there should be some kind of duties also to perform in a society. Okay, so law is a instrument which balance the rights and duties of the individual. Okay, different field of a society have different set of laws. Like in business, we have certain kinds of law. The role of the law is different in business. We deal with contract law, we deal with tort, we deal with criminal law. Okay, while we live in a society, there is certain kinds of laws, like we have fundamental rights given by in a constitution. We have certain kind of fundamental duties. Okay, if we have to live in a society, we should follow some kinds of guidelines, some kinds of laws. Okay, one of the great thinker named Bentham has given. We will learn about this in our later class, but just for a general understanding, Bentham gave a concept of utilitarianism. It means maximum happiness to maximum people. What is the function of law? The law should give maximum happiness to maximum people. Okay. There is another thinker named as Holland. He said law is more than police. Okay. What is the role of the law? To maintain the highest well-being of the society. To maintain the highest well-being of the society. Okay. If we have to generalize the function of law, then we can say that law are such guidelines, are such orders which are sanctioned by some authority, which are made by the superior authority to regulate the human conduct, to provide a mechanism to balance the duties and the rights of the individual. The third one is to maintain the highest well-being of the society. Okay, as Bentham said, the function of law is to give maximum happiness to maximum people. Okay, so these are some of the functions of the law. Excuse me, sir. Okay. Okay, thank you. Okay. There is another thinker, Ross Pond. He said that there is 4 purposes of law. So 4 purposes of law. The first one is, as I said, maintain public order. Maintain status quo in a society. Law enables an individual to have certain freedom, certain freedoms that he can enjoy in a society. Law ensures those freedoms. Okay. And the fourth one is, law gives maximum satisfaction to the people. Okay. Ross Pond gave 4 purposes of law. The first one is law maintain public orders. The second one is law maintain status quo in a society. The third one is law enables an individual to have certain freedoms that he can enjoy in a society. And the fourth one is law gives maximum satisfaction to the people. Okay. So this is the basic foundation in which we have learned about the definition of law. We went through the definition. After that, we learned about the nature of law. Okay, the meaning of law. And the fourth one is the functions of law. In that, we learned about the different thinking of different philosophers regarding the functions of law. Bentham, Holling, Pond, Hegel, every thinkers have their perspective of law. Okay, let's take a break for 5 minutes. After that, we will learn about some aspects of law and morality. Okay. Okay, let's start with the concept of law and moral. Law and morality. Everyone knows what morality is. What is morality? Certain, you know, certain kind of those principles comes within the individual, from within the individual, like inner conscience. Okay. So, if we talk about the concept, the origin of the concept of law and moral, then as I said earlier, if we talk about Hindu society, then in ancient Hindu law, there were no such distinction between law and morality. In ancient system, law is law was not different from morality. Even morality was the basis of the law. Okay. After that, in Mimamsa, it is a kind of a commentary. Certain distinctions were made between obligatory and recommendatory rules. Earlier, there were no such difference. Okay. There were no such difference between law and morality. The moral principles constitute the basic foundation of the law. What moral says is the law. Okay. But with the gradual changes occurred in a society, the nature of law also evolved. Like in Mimamsa, it is kind of a commentary. It is a commentary. In Mimamsa, certain distinctions were made between obligatory rules and recommendatory rules. Indirectly, certain distinctions were made between law and morality. How? Because obligatory rules are those rules which should be implemented anyhow. Okay, that is the obligation upon the society to follow those rules. That's why it is said as obligatory rules. There is an obligation to follow those rules. And recommendatory rules means the authority has recommended that you should do this. It is up to you whether you should follow those rules or not. Morality is that concept, no? In morality, different individual has different kind of morality. They have different moral principles. Every individual has their own moral principles. Those moral principles are not obligatory in nature. They can change. They can vary upon the different mindset of the people. Okay. So with this, there came the distinction between law and morality. We are talking about the Hindu society, okay? After that, there is this doctrine came into picture. Doctrine of factum valid. What does this doctrine say? This doctrine says that if something has already been done and cannot be undone, then law will sometimes treat it valid, even if the nature of the act is immoral. Okay. It means that if something has done, okay, and there is no way to reverse that action, to undo that action, then law sometimes treat it that okay, it has been done, then we will consider it valid. Okay. So this doctrine came into picture, which kind of distinct, which kind of differentiate the nature of law from the nature of morality. And with this, the different aspects of law and morality came into picture. Okay. In Europe also, the doctrine of natural right, in earlier time in Europe, the doctrine of natural right said that in Europe, the doctrine of, sorry, in Europe, yes, the doctrine of natural right had this view that law and moralities are same in nature. Law is not different from moral principle. Okay. It is the earlier point of view of natural right. Okay. Morality morality formulated the theoretical basis of law. Okay. In Roman also there was the same concept in earlier Roman law, that both law and morality is intersecting each other. They have the same basis. Even morality constitute the basic foundation of the law, and law and morality is not different. After the Reformation in Roman laws, it was contended that law and morals are two different entities. As I said, with the changing nature of the society, the distinction came into picture. Before the Reformation of the European laws, it was said that in natural rights, it was said that law and morality is same. They are not different. Morality formulate the theoretical basis of law. Okay. But with the changing nature of the society, the concept, the notion of having the same nature of morality and law changed with the time. Now, morality and law is a different entity. Okay. So, with this, we can say that natural law theory kind of connect natural law theory, natural law of jurisprudence connects law and morality, while the positive school of law differentiate between law and morality. How? As I said, the positive school of law says that laws are nothing but the commands given or sanctioned by the sovereign authority. Okay, there is no place for morality. Only the commands which are given by the superior authority are said to be the laws. And different societies have their set up laws. Okay. After that, there comes sociological school of jurisprudence. There comes philosophical school of jurisprudence, realist school of jurisprudence, historical schools of jurisprudence. We will deal with those schools one by one in our coming classes. Okay. So, this is the basic definition between the conflicting nature of law and morality. Now we will see the difference between the nature of morality and law one by one. Difference between law and morality. We will learn this from the different point of views of thinkers. Okay. There is this thinker named Vinogradov. Vinogradov. He differentiated law and morality by saying that law is submission of individual. Law is submission of individual to the will of organized society. What does it mean? It means that law is the submission of individual. If an individual wants to live in a society, as a human being, we need to live in a society. Okay, we are social beings. We need a society to live in. So, to live in a organized society, you have to submit your will to the society. You should follow, you should obey the guidelines, you should obey the rules, the regulation, the orders given by the society. Okay. While defining the morality, he said that morality is to subject the individual, to his consents. In law, the individual surrendered himself in front of the will of the society. He submits before the organized society. He has to follow the rules made by the society. While in morality, the individual follow his inner conscience. That is what morality is, right? Morality, moral principles comes from within, from the inner conscience of a human being. Everyone has their own definition of right and wrong. Okay, we follow our inner conscience. While law, what is law? Law is made for the external conduct of a human being. Okay, law is made by the society to regulate the conduct of the human being. The individual has submitted his will to the will of a society. While in morality, we follow our principles, we follow our inner conscience. Okay, so this is the difference between the law and morality according to the Vinogradov. After that, there is another thinker named as Dugoit. Okay, he also differentiated the concept of law and morality. He said law has its basis in social conduct. Okay, law has its basis in social conduct. It means that while living in a society, what the individual should do, what the individual should not do, it is governed by the law. While morality goes on intrinsic value of conduct. What the nature of that conduct? It is deal in morality. Okay. There is another thinker named as Patton. He differentiated law and morality by saying that law lays down those principles which are convenient for that time and place. Simply, he says that laws are those principles which are convenient to a particular time, to a particular, in a particular society. As I said, every society has their kind of conduct, okay? So laws are different for different societies. So laws are those convenient principles which are suited to a particular time in a particular situation. Okay. While moral or ethics, we can say, is the study of goodness. Morality emphasize on the individual rather than society. Clear? Laws lays down those principles which are convenient for the particular time in a particular place. While morals or ethics, as we said, morality is the study of goodness. Morality emphasize on the individual, okay, rather than on a society. Okay, so these are some of the differentiations given by different thinkers. You can go through them and study in a more detail. Go through other thinkers as well, okay? Now, let's talk about some basic understanding of custom. Customs plays a very important role in jurisprudence. Everyone knows what custom is. Custom is kya? What? What is custom? Customs are certain practices, okay, recognized by the society. Certain societies have certain kind of practices which has been practiced for so long. Generation to generation, it has coming down. Okay. So, while understanding the laws, we should also go through the sources of law. Okay. There are so many sources of law which we will learn eventually. In those sources, custom plays one of the important aspect. As I said, it is one of the sources of law. Okay. In this also, first, we will go through different, as we are dealing with jurisprudence, we have to go through the thinkers and their perspective regarding the concept. Okay. So, in this also, we will look into different views of different thinkers. First, we will be dealing with Salmon. What did he say regarding the custom? He said that custom is the embodiment of those principles which are sorry which are commanded themselves to national consents as principle of justice and public utility. What does it mean? It means that customs are those principles, customs are those practices which has been accepted broadly. Okay, the society, the general people, the society accepted those principles and followed those principles as a whole. It represents the national consensus. Okay, that's why custom is very important source of law, because those customs which are recognized by the law, okay, those customs should be there because those customs represent the national consent of the state. Okay, there is another thinker named Keaton. He said that customs are those usages which are legally binding. Which are legally binding upon whom the rules are applicable. What does it mean? It means that usages means those practices which are legally binding upon whom the rules are applicable. As I said, different society has their own practices, okay, their customs. Hindus have their customs, Mohammedans have their concept, Christians have their customs. Okay, so customs are those usages which are practiced by a certain section of the society. This definition is given by Keaton. Okay, so these are some of the definitions given by different thinkers. We have to go through these definitions because in the syllabus of UGC NET, the thinkers and their point of view regarding the concepts is very important. You have to go through them. Okay. There is two kind of customs mainly. Customs, there is two kind. One is conventional customs, and the second one is local custom, legal custom, sorry. Conventional customs, those customs are accepted after an agreement, okay, incorporated, accepted through an agreement. Agreement between parties, while the legal customs are those customs which are followed, which have been followed from the time immemorial. Okay, legal customs are existed from time immemorial. Okay. So these are the two kinds of customs, two kinds of customs. Okay. Now, if someone asks us why customs are binding in nature, then we can say that because it represents the national consensus of the people. Okay. Because those established usages is the basis of rational expectation of the society. Those usages are the rational expectations of the society, and the law should respect those expectations. Laws are made for the convenience of the society. So the prime function, the prime objective of law is to entertain the society in a well-being manner. Okay. Okay. One point which should be noted is that in Article 38 of ICJ Charter, ICJ Charter means International Court of Justice. In that charter, under Article 38, it was given that the international convention is considered as one of the important source of international law. Okay, it is given in Article 38 of ICJ. Another sources which were given is International Convention, General Principles of Law, and the International Customs. Okay, all usages, all practices cannot be considered as customs which are legally binding. To have a binding nature, those customs should have certain elements in their nature. For having a valid custom, there are some elements which should be present. Those are essentials of valid custom. The first one is generality. It should be general. General people, everyone should follow that in a particular area, in a particular society. The second one is consistency. Uniformity. It should be consistent. Okay. The third one is duration. It should follow. And it should be backed by the law. The law should recognize those customs backed by law. Okay. So these are the essential conditions of the custom. With this, we have looked into the basic understanding of custom. Okay. Now, let's talk about a little bit. Let's talk about a little bit about rule of law. Everyone has heard about this concept, rule of law. It is a concept given by David, I say. Okay. In his book, The Law of Constitution. Okay. What does a rule of law talk about? What does it mean? Rule of law is the ultimate expression of the human civilization. As I said, to live in a society in a well-being manner, in a welfare manner, in a civilized manner, we need law to regulate ourselves. Okay, so rule of law means the law should be the supreme authority. Everyone should be under the ambit of the law. Everyone should follow the law of a particular place, of a particular situation. Okay, so rule of law is the ultimate expression of human civilization. It guarantees the validity. It guarantees the validity of the Constitution. Constitution talks about the rule of law, right? Constitution says that every citizen, every individual living in a particular state should follow the laws given in the Constitution. So Constitution talks about the rule of law. Okay. It the rule of law balance between rights and privileges. Duties. Okay. So these are some of the functions, we can say these are the elements of the concept of rule of law. Okay. If we talk about the rule of law in the context of Indian Constitution, then the preamble of Constitution itself, mentioned rule of law through the words equality, justice, liberty. Through these words, the rule of law has been incorporated. Okay. Now, if we talk about the fundamental rights, everyone knows what are the fundamental rights given in Part 3 of Indian Constitution. Okay. Fundamental rights such as Article 14, Article 15, okay, Article 19, 21, 22, 20. These articles directly, indirectly laid the foundation of rule of law. For example, Article 14 talks about equality. Everyone is equal in front of law. Everyone is equal before the law. Okay. Article 15, Article 19, Article 21, 22, 20. These articles, Article 15, no discrimination on the ground of caste, religion, sex, birth of place. Okay. Article 19, speech and expression. Okay. 21, right to life and personal liberty. Such articles talks about, such articles laid the foundation of rule of law in our constitution. Uh, Everyone knows Article 32 and 226. Article 32 empowers the Supreme Court for judicial review. Okay. Article 226 empowers the High Court to check whether the laws are constitutionally valid or not. The laws made by the legislatures, were those laws, are those laws, will those laws be constitutionally valid? Are those laws infringing the fundamental right, infringing the basic structure of the constitution or not? It check upon the powers of the legislatures. Okay. So rule of law consists of the supremacy of law, basic essentials of rule of law. Law is supreme. Everyone living in a society has to follow the law. Okay. All the things should be done accordance with the law. There should be equality before law. And there is another concept, equal protection of law. Equality before law and equal protection of law. There should be independent judiciary, which has the power to check whether the legislatures are acting within their power or not. There should not be any arbitrary, there should not be any excessive use of power given to the legislature, given to the executive. The judiciary has the role to have a check on those functions of the both organs, that is legislature and judiciary. Okay. There are some landmark cases. Everyone has heard about Keshwanand Bharti case. Keshwanand Bharti case, which laid the foundation of basic structure and said that rule of law constitute a basic structure of constitution. Okay, rule of law constitute a basic structure of constitution. The second case is Indira Gandhi versus Raj Narayan. In this case also, rule of law has been said to be the basic structure of the constitution. Okay. State of Bihar versus Sonawati. In this, executive government is bound to follow the rule of law. So these are some of the cases which said that rule of law is the basic structure of constitution. Okay. Okay. Now, if we talk about the equality before law and equal protection of law, both these phrase sounds similar, right? But they have a very big difference in understanding. Equality before law says that everyone, no matter how powerful an individual is or how underprivileged, how weak an individual is, everyone is equal before law. Okay, law treats everyone equally. No privilege should be given to any particular person. Okay, equality before law talks about that. It is kind of giving a negative connotation. Why negative? Because it has been said that no privilege should be given to any particular person. Everyone is equal. While equal protection of law says that no, everyone is not equal. Then what about the weaker section of the society? How can we develop the weaker section of the society if we treat them with the superior section? We have to give certain advantages to the weaker section of the society to make them more developed. Okay, so equal protection of law is kind of positive connotation because it talks about positive discrimination given to the weaker sections of society, like women, like children, like reserved categories, SC, ST. To those sections of the society, some privilege, some advantages should be given so that they can come with the pace of superiors. So, with this, we have completed the basic. I'm emphasizing on the word basic. Okay, this is our first class, so we have tried to understand the basic foundations of such concepts. Gradually, we will deal with such concepts in more detail, and we will go through different cases and different other aspects of the law. Okay, so with this, we have completed the foundation of the law. We have completed the nature. We have completed the meaning of the law. And we have seen some essential elements of rule of law. Okay. Okay. We learned about the customs. What are the essential ingredients that should be present in a valid custom? Every practices cannot be constituted as valid custom. For a valid custom, there are certain elements which should be present. Okay. We talked about law and moral. We talked about differentiations between law and morality, different definitions, different thinkings given by the different views, given by the different thinkers. Okay. So with this, we are done with today's class. Thank you, everyone. So,
Thank you, ma'am.
thank you.
Thank you, ma'am.
Thank you. Okay.
Yes.
Okay.
Okay, thanks.
So the mic.
Yes.